So, 3 or 4 ideas I want to share with you. First of all, my presentation is named as the victimology of international law. Not the idea of the rights and needs of the victims in law, not the idea of the law on the rights of the victims. These problems are mostly understandable by the whole society. Sometimes one could say that there's 3 dimensions or 3 ways which were used for understanding of what victimology or what some process of analyzing law is. The first one is traditional legal. The second one is connected with the misuse of law. Sometimes we do forget that misuse of law and, well, all of the kind of activity which are connected with the political processes, with abuse of law, are forgotten. These are not a crime, these are not a constitute a violation, but sometimes it is mostly obvious and mostly popular in some dimensions when our jurisdiction, the jurisdiction of the state, can't be working. For example, let's look at Ukraine. We have the territory which is controlled by the government, and we have the territory which is controlled by the invasion from the side of one foreign state, and we have the territory which is controlled by an armed forces. And that the territories which are controlled by the armed forces, they have a specific jurisdiction. A specific jurisdiction which is null and void for us. It is no law at the Hegel's word. It is anti-law. But they have their own criminal codes. And they work with these criminal codes. The criminal codes of Donetsk Republic of 2015, the criminal code of Luhansk Republic of 2014. These are the documents they work. And these documents which work with the help of quasi-judges, quasi-system. And one could analyze what we have to do with that. For example, I don't know what they have to do with Transnistria. They have their local documents, and when Moldova just ratifies the Rome Statute, what jurisdiction we have under Transnistria's law and the Transnistria's situation. We're located just 30 miles from this border, and I understand that sometimes the violation of human rights in this region are of great impact up to the region as a whole. And that is why this violation gives the third approach we could do, the approach which is connected with law, no law, and misuse of law as the common system. And that is why when I say about international criminal law in this field, one could say about this mixture. We don't know what I have to say, for example, for Guantanamo prisoners, and what I have to say about secret prison, and so on and so forth. That is the second, third, another way of understanding what I have to do for strengthening the criminal justice. But from the other view, we have to say that all of this discussion could be overridden, could be faced from one point to another, and this point is the rights and needs of the victim. Providing of victims' rights in international criminal law, as for me, that is the aim of preventing international conflicts in the future. Some people say that victimology, that is the path of treatment of victims of crime and their role in criminal behavior and so on and so forth. Well, that is true, but victimology of law means that we are trying to make a normative approach in victims' rights and needs. Yes, from the traditional normative approach, we said that the United Nations Declaration of Basic Principles of Justice for Victims of Crimes and Victims of Abuse of Power, the United Nations Guidelines for Justice in matters involving child victims, and as for me, is the main document in international criminal justice, which is hidden, it is forbidden. When we say, everybody is saying about the UN Declaration, UN basic principles of justice for victims of crime. This document of 1995 is very popular and very trendy. I was one of the experts who, I'm proud of it, but I was one of the experts who just prepared a textbook, United Nations textbook on this declaration. But from the other side, this year in 1995, the United Nations General Assembly has adopted another document, more interesting and mostly sophisticated in the field of international criminal justice, which was based upon the ICC and the ideas of ICC. I mean the United Nations basic principles and guidelines on the right to remedy and reparation for victims of gross violation of international human rights law and serious violation of international humanitarian law. That is a very interesting document, the document where the analysis of the elements of the rights of the victims gives another glimpse which in international victimology we can't do. For example, the Rome Statute requires the establishment of principles relating to reparations in respect of victims, including restitution, compensation, and rehabilitation. UN required established a trust fund, and this trust fund for victims of international crimes was done. Is working. Just to Saska said about the problems, I said about the 1% of implementing of the idea, but the idea is, and it is working. That's the main. It's working shortly. That's the first steps, the very short steps. But try to understand. In this country, 25 years ago, we just prepared a new legislation on compensation of victims of crime. 25 years ago. We have 2 state programs. We have 5 or 7 drafts of law. We have 2 articles in our civil code, Article 1177 and Article 1178, when the state is obliged to compensate all the assets which are connected with the crime. But to permit that, everybody said that there's no in the world, because there is no possibility to do that due to the economic tradition. On supranational level, I want to say that international criminal justice, international criminal victimological processes, we have a very interesting document which, as for me, that is the future of understanding what they have to do with the victims of crime in transnational, supranational, or international level. This name of the document is the Directive 2012-29 of the European Union, establishing minimum standards and rights, support, and protection of victims of crime, which, under normative approach, gives all the interesting moments concerning the rights of the victims. The another point, the point that I'm interested in more, is the standard gap between the characteristics of the victims, especially international victims of crimes, and hybrid or virtual responsibility of international society. The case is that in transnational crimes are so many victims. Sometimes the state is a victim too, and the collective victims, like a state or social groups like in Rwanda, the acts of genocide, we can't say and can't collect every victim. Sometimes we have the another process, sometimes we have the overreacting or overwhelming when one point of coin reverses to another point, and former victims became the criminals under the jurisdiction of the international court. That is the case because that's a very complicated question to understand what we have to do with that. And global respect and global regret to every victim, from the position of Africans or from the position of Europeans, deserves the third approach, the sensibility, the sensual approach of what victim is. As for us, for Europeans, yes, that is understanding. Or just sometimes it's not understandable too. Well, I remember the fact when I was young, well, that was the first my victimological conference, which is one of my scientific advisors and former teachers, Professor Emilio Viana, who is the president of International Criminological Society, has attended. It was in Spain, and my American friends are discussing the problems of well, psychological trauma from of policemen who just look at family violence. This was the period of time when the Soviet Union was collapsed. We have tanks in Baku, tanks in Vilnius, we have demonstration, we have blood on the streets and so on and so forth, and we were discussing the problems of post-traumatic stress disorder of policemen who were involved in family violence conflict. Different approach, different understanding, yes, different senses, but these senses are equal. And equality of the senses means that the victim in Africa has the same, had the same rights and the same sensibility and sensuality like the victim in Europe. Sometimes it's not understandable, especially when we say when we talk about the victims' rights and victims' abuses from in the communication level. Pardon me, but when we have a terror act in Paris and terror act in Turkey, these are the same terrorist acts, but these are not the same in understanding of the mass media. Because for the media, it is interesting to say about the French and French victims, not about Turkey victims, because in Turkey this process is mostly common. And we can't say anything about the situation, for example, in Rwanda. In Darfur, it is obvious, but that is affected only International Criminal Court and international prosecutors' offices who are working here could do that. Now we have only one mechanism. We have the proper understanding of what we have to do with that. But we have to do it. We have to solve that. We have to make a suggestion in the field. Sometimes we have a very interesting moment which are connected with the sensuality. Just try to understand that. And in Rome Institute, there was one question that Kant shared among this is the international society, the case of inspiration. What does it mean? Victims' rights which were given in The Hague are connected with the right to participate in proceedings, the right to request reparation, and the right to legal representation. That is great. But the word is challenged, and that's why sometimes one could say about symbolic reparation or the right to satisfaction. Do you satisfy it? Do you understand yourself as a victim? Do you satisfied with these elements which government, media, other resources like other society, not only society, but civil society should do? Sometimes we can't. Sometimes, and the United Nations says that the symbolic reparation is connected with the specific effective measure with the cessation of continuing violations of their right. These measures are represented, now they're represented in all the international documents. I don't want to put them all, they mostly 12 or 17 specific measures, but If you want, you will get it. The idea is that the rights of victims should be emphasized as the whole rights of the mankind, because the mankind is the main victim of the international transnational crimes. The safety of mankind sometimes should be better understandable via this process, because the object of the crime, when we say about the safety and the safety of the mankind as a whole, well, that is the new approach, the new holistic approach. We are trying to unify all. And that is why the legal rights in the area of victim protection give the new possibility to understand what they have to do. As for me, it's very interesting. One more question is mostly interesting as for me. Well, it is not a revolution to lawyers, but try to understand. In cases of the European Court of Human Rights, Wilson against United States, and then Hutchinson against United States, so this HR, pardon me, has created a new paradigm, a new shift in the law of human rights, a paradigm of the right to happiness. The right to happiness, which was at first made by ancient philosophers and then by the Constitution of the United States of America, has to be realized in the idea that we have the right to be protected. And the right to be protected means that sometimes we have the right to be punished too. Not to be protected. How do you understand the right to be punished? It means the right that you have the right to be punished by the fair trial. Not but by the civil society. You know that, for example, here in Ukraine we have a very interesting process, yes? Garbage judgment, when some people were taken and put into the garbage. And they say, wow, that is, the civil society works with these people because they are corrupt officers, they're the representatives with the old powers, and so on and so forth. But I don't know why in present democracies we have such processes. That is, the abuse of powers, and this abuse of powers could be understandable from the point of view of the victims of abuses. This approach means that we have to, as for me, we have to reconstruct, just begin to reconstruct the domestic criminal codes when the first block can't be connected with the ideas of what the crime is, what the responsibility is, what the jurisdiction is, but the first block can't be connected with the sanctions. How could people be penalized? How could people be under-victimized? Because the sanction means that victim has the right to be involved in. That is not an ancient period of time when we are trying to understand what they have to do with that. But the law of Talion, you know that. That is the new era of understanding of penalizing process with the help of the ordinary people. The penalizing, well, maybe sometimes one could say that when we now we say that the impact state order or in protecting order in the victims protective order in Europe, that is something new and something understandable. But try to find the one motto. 20 years ago, European warrant was not understandable by anybody. We say, okay, it's impossible to do, but it's a reality now. That's a real, points of standing up to new era of new justice. The Commonwealth, the justice of Commonwealth, supranational, international, but the idea of safety, of world safety, has connected with this idea, with the victimization and the sphere of legal, the victimization of the sphere of social. Well, sometimes one could say about the process which are stressed on specific methodological approach in the field. I don't know where it is right or not, but 10 years ago, one of the famous, not 10 but 20 years ago, one of the famous Russian scientists who was the first, professor who began to study victimology in the Soviet Union, yeah, Mr. Frank, he said that this was the last phrase in his book, the victimology of today, that is the criminology of tomorrow. And that is the case that we are trying to understand the new era of international law in the field of victims' rights and victims' approach. I don't know whether it's right or not, but we are trying. Let's try. Maybe you share some ideas in the field. Thank you very much.